both in the Butler County District Court, entitled State of Kansas versus Quentin Lawrence Height. It's case number 2025 TR 1215 and 2025 CR 261. Jared Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. William Peterson as defense counsel. Quentin Height appears from the Butler County Detention Facility Zoom location. Court will review. This matter last came before the court on October 21, 2025. At that time, a hearing was conducted primarily on discovery issues. The court made certain orders of turnover of reports and materials. The court granted no relief otherwise on the subpoena quash order that the court had earlier made. Court then proceeded to take up a request by the defendant to continue the jury trial, and that was granted. The case was reset for jury at December 10, 9:00 a.m. with a pretrial conference established December 3 at 4:00 p.m. That time it was announced that the pretrial conference would also be in person. The court reaffirmed its bench warrant bond forfeiture no bond hold order due to the defendant's failure to appear previously. The defendant was placed in custody with a no bond hold. Court set a discovery compliance review hearing for today by Zoom, and the court, of course, contemplated the defendant would participate from the county jail. Subsequent to that hearing, apparently Mr. Peterson has been retained to represent this defendant in both cases. Is that correct, Mr. Peterson?
Yes, it is, Your Honor.
All right. Is there any progress to announce regarding case disposition?
Yes, Your Honor. There has been in my short time on this matter. I've had a couple of discussions with Mr. Regier, including a phone conversation yesterday in which we talked about previous plea discussions, and that my client did inquire about diversion eligibility here. Mr. Regier referred me to their rules, which my reading, I don't think there's anything in there that precludes an offer of diversion if Mr. Height applies, which he would like to do. Also, Mr. Regier did send over an offer in regards to resolving this matter that my client and I have discussed briefly, and I believe that it also has, well, it's something we discussed as being able to, it's amenable to my client, I should say. But again, the diversion option is something that he would like to also look into. So at this point, Your Honor, we're prepared to let the court, set aside any future or any discussion on discovery compliance or any further discussion on the motion to quash, and even take the matter off the trial calendar if the court's inclined to do so, and allow my client to decide which of these two routes he'd like to go.
All right. As previously announced, Mr. Peterson, I do have a pretrial conference set December 3rd at 4:00. I could convert that to Zoom, but the court wouldn't want this case or these cases to fall off the calendar. If the defense is specifically requesting I take it off the jury trial docket, I will, but I would want to leave the pretrial conference setting if you're available. Mr. Peterson, your availability by Zoom, December 3 at 4:00?
Yes. And my hesitation, Your Honor, I was going to request that in person because Zoom is not our favorite thing to do. And what I mean by that is I'm in Topeka. Mr. Height is down there. We've got to travel to be in the same room anyway. And for other reasons, we prefer an in-person hearing, which...
Well, Mr. Peterson, I tried to do that as an accommodation to you.
I appreciate that.
If you want an in-person hearing, I think that's how it was originally set.
Yes.
And the court can maintain that as an in-person. All right. December 3, 4:00. The court will essentially set it for a pretrial status hearing. And I can remove this case off of the jury trial calendar for the December 10th date at counsel's request. Is that what you're asking the court to do, Mr. Peterson, specifically?
Yes, Your Honor.
Very well. court will make that order. All right. With our next court date set and the matters that have been announced, is there anything else that we need to address at this hearing, Mr. Peterson?
Your Honor, I did file a motion to set aside the forfeiture of the bond in both of these matters. And I
You
was
may
wondering.
proceed further on that motion if you desire, Mr. Peterson.
Yes, I would like to be heard on that. As I stated in the motion, Your Honor, Mr. Height is asking the court to set those forfeitures aside. A couple things I would just add from the motion, and I think it did include Mr. Height doesn't have a lot of experience with the criminal justice system, and he did, as you're aware now, heed the warnings of the court to hire counsel, get some assistance. He's done that, and I think moreover spent the last couple of weeks in a lot of self-reflection and thought about how to handle these types of situations and how to handle this current situation. And he is, like I said, taking steps to rectify this and make sure he's never put himself in this type of position again. I think that the court's forfeiture of the bond and him sitting in jail has shown Mr. Height the ways of, it's important to always adhere to the court's rules, adhere to procedure, and is asking the court to allow him an opportunity to show that he can do that. We have an in-person setting, engage in discussions. He's taken steps to rectify, what the registration offenses, as I put in the motion, prior to being placed in custody. And again, back to his very limited contact with the court system and law enforcement previous to these two cases, I think Mr. Height is in a position where searching for a phrase, but learned his lesson is this kind of one that jumps out at me at this point. So he is asking the court to, in the interest of justice, and these, they're misdemeanors. He's aware of, what he's accused with and the very serious nature of interference with law enforcement. And but he'd like an opportunity to show the court that he can do this without, move forward without being in custody and resolve these matters.
Very well, Mr. Peterson. I am familiar with the contents of your motion to set aside bond forfeiture previously filed. Mr. Regier, on behalf of your office, what is your position regarding this request?
Your Honor, with all due respect to the court and counsel, the state's position is the court's prior order should be maintained. These are two cases where the court found the defendant disregarded the orders of the court and failed to appear for a critical in-person motions hearing on October 2nd, which the state does consider troubling, especially since the defendant filed multiple demands for in-person hearings in both cases in July. It would appear that between the October 2nd and the October 21st setting, rather than submitting himself to the authority of law enforcement, the defendant filed 3 separate motions in each case, 6 total in the aggregate. And it is the state's understanding that it was only through extraordinary measures taken by third parties that the defendant successfully appeared in court during the October 21st hearing. The state further understands that this court heard argument on the issue of bond at the October 21st hearing, and it would appear that the arguments raised by counsel for the defense in the motion are largely similar, if not identical, to the same arguments raised at that setting. And at that setting, the court did find that a cash or professional surety bond was not appropriate in either of these cases. Based on the procedural history of these cases, it does appear that this is a defendant who's able to file a number of motions and subpoenas and to retain private counsel, but not to appear in court when ordered. And the state is not aware of any new information which might reasonably justify the modification of the court's prior orders. So the state's position is the court's prior order should be maintained.
Mr. Regier, you make some good points and you articulate your position well. However, I think there has been one material change in the status of this case, which this court should take into account, and that is counsel's involvement, which was not present previously, which in the view of the court would help to cut down any of the what the court would deem communication issues that we've experienced in the past regarding Mr. Height and his cases. But before the court makes a ruling in this case, Mr. Peterson, the court has several conditions it would impose. Number one, I want a statement on the record right now from Mr. Height as to where he will be residing. And I don't want a P.O. box. I want an actual street address where he is representing to this court is his residential address.
The address that is on my driver's license is current the road. I do have a question. This is
All
being
right, Mr. Height, let me back up a minute. I hope you're just not playing word games. I want to know where you're actually going to be staying. I don't care what's on your driver's license. I want to know where you're actually going to be sleeping at night, where you're going to reside. Is that the actual residence where you live?
Yes, it is.
All right. Fair enough. You've been asked a question by the court. You have one for the court, Mr. Height. Be careful.
I was just going to raise a concern about the live streaming and of me putting my address out onto the internet. That was all.
I understand your concern, Mr. Height. I trust anyone who is familiar with the internet could probably locate that address if they wanted. All right, the second requirement, Mr. Peterson, and it's a simple one, and that is this court would require as a condition of bond or your agreement, Mr. Peterson, as counsel in the case, to confirm in writing after each court appearance the date, time, and location of Mr. Height's next appearance and confirm that with your client in writing. I would need that commitment from you.
Absolutely, Your Honor. Standard of practice.
Indeed. Indeed, it should be. You'd be surprised, however, Mr. Peterson, how many attorneys these days do not do that.
I understand.
Thank you for that commitment, counsel. I'm satisfied. I think that some of the problems we've had in the past have been adequately addressed by what we've talked about today. This court at this time will, reinstate the cash bond in each of these two cases, set aside any particular order of forfeiture that might lead to judgment on bond. You're back on bond, cash bond in both cases, Mr. Height. I will order your immediate release on these two cases. If for some reason you have other holds that we haven't discussed here, I'm not releasing you from those. But in regards to the two cases currently before the court, I'm going to reinstate bonds on both with the conditions and matters that we've discussed here in this hearing. Any questions about that, Mr. Height?
Not at this time.
All right. We have another court date set, December 3 at 4 o'clock. The court's ordering Mr. Height, as a condition of bond, of course, to appear at that time, Courtroom B, Butler County Judicial Center, for further proceedings in the case, which will be conducted as an in-person proceeding. All right, Mr. Peterson, with those rulings made, which I will expect you to promptly document through order, is there anything else from your perspective that we need to address at this time?
No, Your Honor, that has covered everything I have.
I think there's been certainly some discussion here about some matters being resolved by more or less agreement. I would hope that that will be moved on quickly so that there can be an appropriate announcement made on December 3, at least regarding the progress of those matters.
Absolutely.
All right. Thank you, Mr. Peterson. Mr. Regier, anything further that we need to address currently?
Not from the state's perspective, Your Honor.
Very well. I trust that there is someone from the detention facility who is hearing the court's orders and the order of release.
Yes, Your Honor.
All right. Essentially, it's reinstating of the prior cash bonds in the matter and releasing the no bond hold that was previously put on him by this court. All right. Thank you. I appreciate your involvement as well. If there's nothing further, then the Quentin Lawrence Height matter, or both cases, will be in recess at this time, and this meeting may be ended for all.